Hi friends, in this video we are going to deal with the important judgment titled Dr. Harish Kumar Khurana versus Joginder Singh and others, pronounced on 7th September 2021. This judgment deals with that a medical practitioner cannot be held negligent merely because the treatment is not successful or the patient dies during surgery. To know more about the case synopsis, please watch the video fully. The facts of the case would be that the claimant's wife, who was admitted in the hospital after being diagnosed with kidney stone, died after a surgery. Alleging medical negligence, the claimant approached the National Consumer Disputes Redressal Commission. The National Commission held that the doctor and hospital guilty of medical negligence and directed payment of rupees 17 lakhs with interest as compensation. The allegation against the doctor and the hospital is that they did not exercise the care which was required in treating the patient. The said negligence on part of the doctors as well as the hospital had resulted in the death of the patient. The Supreme Court has held that in every case where the treatment is not successful or the patient dies during surgery, it cannot be automatically assumed that the medical professional was negligent. To indicate negligence, there should be material available on record or else appropriate medical evidence should be tendered. The negligence alleged should be so glaring in which even the principle of res ipsa loquitur could be made applicable and not based on perception. In the instant case, apart from the allegations made by the claimants before the National Commission, both in the complaint and in the affidavit filed in the proceedings, there is no other medical evidence tendered by the complainant to indicate negligence on part of the doctors who on their own behalf had explained their position relating to the medical process in their affidavit to explain there was no negligence. In the instant case, it is not a situation that the diagnosis was wrong. The fact of both the kidneys requiring to be operated is the admitted position. The two aspects which are the foundation for allegation of negligence is that no care was taken despite the observation of the surgeon after the first surgery that the patient is poorly tolerant to anesthesia. The second aspect is as to whether the patient's life was exposed to risk by advising and preparing for the second operation without sufficient gap after the first operation. Any of the shortcoming relating to infrastructure as mentioned in the report of the magisterial inquiry will become material only if the medical evidence is to the effect that the said two aspects were not the normal situation and that undertaking operation in such situation with reference to the medical condition of the patient was a high risk procedure. The backup that ought to have been ensured and whether the medical equipment that were available at that point in time were sufficient. When there was no medical evidence available before the National Commission on the crucial medical aspect which required such opinion, the mere reliance placed on the magisterial inquiry would not be sufficient. Though the opinion of the civil surgeon who was a member of the committee is contained in the report, the same cannot be taken as conclusive since such report does not have the statutory flavor, nor was the civil surgeon who had tendered his opinion available for cross-examination or seeking answers by way of interrogatories on the medical aspects. Therefore, if all these aspects are kept in view, the correctness or otherwise of the line of treatment and the decision to conduct the operation and the method followed were all required to be considered in the background of the medical evidence in the particular facts of this case. As indicated, the mere legal principles and the general standard of assessment was not sufficient in a matter of the present nature, when the very same patient in the same setup had undergone a successful operation conducted by the same team of doctors. Hence, the conclusion as reached by the National Commission is not sustainable. Friends, to conclude, in this video we have seen that a medical practitioner cannot be held negligent merely because the treatment is not successful or the patient dies during surgery, as per Dr. Harish Kumar Khurana versus Joginder Singh and others case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.